Virginia Williams individually. Mr. Dwayne DeVault's present as counsel of record for the estate. Ms. Shannon Emick is president counsel for the petitioners, which is a group of the heirs, David Stephen and Jamie Michelle Denton and the Elliots. And this is a status conference on the estate. However, there are several motions that were set for hearing today. I'd like to give some context. This centers around the court's order in this matter that was entered on April 15th, based upon rulings from the last hearing on this matter on March the 3rd. And on May the 14th, Ms. Williams and the estate both jointly filed several motions, specifically a Rule 5904 motion to alter or amend this court's order based on the grounds of the application of the rules regarding Rule 3601 of civil procedure, specifically regarding requests for admissions that were submitted to the Elliots, the petitioners, that were not timely responded to pursuant to an agreed scheduling order that was executed on November 20th of 2025. So for that basis, Ms. Williams and the estate are requesting that this court alter or amend its judgment, granting a good cause for a 10-day extension for the petitioner's late responses to those discovery requests. It is the respondent's position that there was insufficient good cause. Alternatively, Ms. Williams and the estate have also jointly filed a motion for an interlocutory appeal on that limited basis under Rule 9 of Appellate Procedure for a limited issue of whether the petitioners failed to answer respondents' request for admission within the time provided and whether or not this court had the discretion to grant that extension. Additionally, we've also filed a joint motion to stay the estate proceedings and the proceedings on the petition to remove the administrator under Tennessee Rule 62 of civil procedure. This court has the discretion under Rule 6201, 6207, and 6209 to make that discretion and stay all of the proceedings and all these deadlines. It is the respondent's position that the motions that were jointly filed stayed and told the applicable deadlines and the finality of this court's order that was entered April 15th. Those motions were jointly filed on May the 14th. This court's order from April 15th had a deadline of completing all written discovery and all discovery by June 30th, 2026. It is the respondent and the estate's position that those deadlines are not binding or final yet, pending the court's ruling on these joint motions. Now, the petitioners have not provided a timely response to the joint motions. I believe they filed a late, untimely response yesterday, raising concerns about the respondents' arguments and based on the law that was cited. But it is the respondent's position that has the court does have some discretion in staying these proceedings, but it's the respondent's position that this court does not have the discretion to grant the 10-day extension of those deadlines under an agreed scheduling order that was willingly signed by counsel for the petitioners that agreed these deadlines that were passed and not complied with. Rule 36.02 of civil procedure uses the phrase conclusively established. When admissions are deemed admitted in a civil action, it is conclusively established of those admissions into the record for purposes of trial unless, by motion, the party requests withdrawal or amendment of those responses. That was not timely done before that deadline passed. It was filed late. And also an expedited motion with a request for a 2604 protective order and a compilation of other motions. I'll defer to Mr. DeVault regarding the concerns that the estate has about this matter.
Your Honor, may it please the court, Dwayne DeVault of Nashville and Sumner County Bar. We ratify and reaffirm everything that statement for Mr. Triplett has made to the court representations. We're here on 3 motions. I would refresh the recollection of the court that we entered into a scheduling order pursuant to the instructions of Your Honor on the November 5th hearing. And we complied with that. We propounded written discovery, excuse me, to include requests for admissions, requests for production of documents, and written interrogatories. I hand-delivered all those documents to the Elliott's counsel on Friday, December the 4th, thereby leaving them, pursuant to the rules of civil procedure, 30 days to comply with not only the rules of civil procedure, but the order of this court, that all written discovery be completed by January 5th. During the month of November and December, I went to my post office box almost every day except for Thanksgiving and Christmas and Sundays, expecting written discovery from the Elliots. None was propounded until after the deadline. Ms. Emick provided a notice for a deposition of Ms. Williams. We objected to that notice because she did not include all of the parties. She did not notice any of the Murphys, who are in the same position, beneficiaries of half the estate as the Elliots are. We filed two other objections to the deposition. They are remaining with the court, and we preferred those to the court at a previous hearing. And then we scheduled a deposition for the Elliots on February the 4th. We were all present, Mr. Triplett and I, at Cobb Law in Hendersonville at 10 o'clock, ready to commence the depositions. We sat there 10:15, 10:30, 10:45. Mr. Triplett sent Ms. Emick an email saying, "Where are you? Are you coming to the deposition?" She responded, "My clients aren't available, and why do you think you can depose the Elliots?" We have complied with this court's order, the rules of civil procedure, and here we are 8 months and 3 days later, and we don't have one single document in response from our request for production of documents to the Elliots, which again I hand-delivered to their counsel on Friday, December the 4th. Your Honor, we object to the late filing of a response to our three motions. We object to this court allowing Ms. Emick to respond in opposition, and we recommend and suggest that this court should grant our motions. Thank you, Your Honor.
Good morning, Your Honor. Of course, we're going to ask the court to deny all their motions. We're also going to ask this court to require a bond if Ms. Virginia Williams is allowed to continue as personal representative. And here's our reasoning. We have been trying to get financial documents since July of 2023. We've made over a dozen requests for those. My last email to Dwayne DeVault was, maybe please have the accounting so we can close up this estate. Delay after delay, a dozen requests, and Your Honor denied my request for subpoenas and stated that we need to go through discovery. That was at the November 5th hearing. And so your order quotes that the motion or the discovery shall be due within 30 days, or just like the rule says, or within a time that the judge allows with discretion. After hearing the facts or the reasoning behind the delay, I contacted you and ran your court assistant down trying to get in front of the court, but to get that extension. But unfortunately, the way the judges rotate, I wasn't able to get in front of you. The hard thing about this is that the opposing party didn't follow the local rules, and it's baffling to me because I did everything I could to notify them that I was going to be a little late because of the holidays, and good faith said I needed a few more days just to get the notarization. And instead of conferring, like the local rule, I think 6.03, I believe, states that we are to confer before filing anything with this court, they filed the motion to deem admitted a day before I said that I would have the responses. And now what they are arguing is that this court doesn't have the ability or to act within its discretion to extend that time. They are quoting a law that is not, or they're quoting language from a law that, or a case law that does not exist, Your Honor. I spent hours trying to find where these cases that they quoted stated that it was mandatory. And the only thing, and I've got a copy of the cases that I can put together. I've got a couple of copies. States nowhere that it is mandatory to deem it admitted. It is a civil conspiracy case. There's a fraudulent case that they quote, and the only reasoning I can think of is it's possibly AI generated, being that I have a lot of experience with AI myself. It is a way to get this argument in front of the court without real case authority. And as far as the motion to alter amend, it states that the court committed a manifest error by not deeming the omissions, and that this court did not have the authority or the discretion to extend it. I argue that this is just another delay tactic. What we do know is that there was never conservatorship or estate bank accounts opened until maybe recently, maybe a year ago. We do know that all of the funds from the conservatorship and the estate ran through an account with Virginia Williams' names on it. We do know that there's over $600,000 missing from the conservatorship to today. And we do know that we can prove the damages if we are allowed to get the financial documents. But it just appears that whatever we do, whatever we come to this court on, they're going to find a way to dodge it. And, Your Honor, we're asking that we just move forward with mediation, that the requests for documents that I sent to them were requests that for those financial records that my clients are entitled to. It's their inheritance. They should know what's going on with it. The interesting thing, too, Your Honor, is that we propounded our requests for documentation back in January, and they never provided them. I sent a good faith letter to confer about what's the status before I filed my motion to compel, and they're silent. They use the court to try and delay and get this court to punish us when they're not following the rules themselves. And so, Your Honor, we are asking that we can just move forward. If the court asks them to produce the documents that we've requested, then give a strict timeline. If not, let us move forward with subpoenas. We want to just get this matter open and set a final hearing for today, set a final hearing, deny these motions, and set that final hearing so we can put this to rest. The request that they made to us, and I explained it, and I even quoted the law, is that documents that are readily available in the court or in public record, we are not required to produce those. Every answer that I submitted to them was, this is an exhibit A through N, or exhibit here that was filed on this date. It's in the court's record. They're claiming that we didn't produce the documents, but they were readily available in the court. Also, the documents that they're requesting from us are all the documents that they provided to the court. And so it's just another way to stall, delay, keep this thing moving when we've got a 3-4-year-old case that's been open. We know that things have been done, and we want the final answer and the final number of what those damages are. So we ask that, lastly, Your Honor, that we, like I said, just require mediation and just set a date for the final hearing.
So you want mediation, or you want to set a final hearing?
Well, we can't really, I know it's the laws, the local rules.
I've handled
mediation.
this case for a couple of years now. With all due respect to fine attorneys on both sides, I don't think mediation is going to result in any kind of an agreement.
That's fair, Your Honor. I didn't know you had ordered it in your last order.
Yeah, well, it's optimism on my part that is unwarranted. So.
We just need the financials that we're requesting before we can have a final hearing.
Mr. Duvall, co-counsel has indicated that there were documents or some discovery that you had not supplied to them. Are those the documents you're saying that you refer to that are available in public record?
Yes, Your Honor.
And what specifically are those?
The documents about the conservatorship, the numbers that are quoted in the conservatorship accounting. I'd have to look at all of it, but each of the questions, or they were asking for documents that my client didn't have. Their questions or their requests are trying to prove that my client, Jamie Denton, was part of all this. And their own client stated under oath that she absolutely did not allow Jamie Denton to see records, didn't provide the records.
But wouldn't it be a simple situation to say, we don't possess those records? In the answer,
I did in some of the answers, Your Honor. In the questions where they asked about our note or my client's notes or accountings or anything, that I did state that we do not possess those.
I interrupted you. Is that all you had to say?
That's pretty much it, Your Honor. They just were requesting that this court deny their motions. I have a motion to compel, which was done after I requested under, like the local rules requires, motion to compel the documents that we requested back in January. And that, Your Honor, their argument that their motions stay any discovery, that just deny that argument as well, Your Honor. And set a bond, please.
Your Honor, if I may respond briefly. I appreciate Ms. Emick bringing up her motion to compel, because that motion to compel was filed on July 1st. It was filed on July 1st because it's based upon this court's June 30th deadline, based on the order that was entered April 15th, that has not become final yet. That is the whole purpose of the three motions that are pending before this court, is asking the court for motion to alter or amend that exact order that has not become final, because based on the pattern of issues throughout the discovery process, the lack of compliance with the original agreed upon scheduling order created all of these issues. Now, if there was a motion to compel in January, or if we could reach an agreement about 10 days extension, or if there was sufficient good cause for delays in producing discovery, we probably would not be here today. But it is a consistent pattern of no production, late written responses, outright refusal to appear to depositions. That was the whole premise of a joint motion for sanctions being filed. This court has described this case, unfortunately, as a contentious and acrimonious case. Nobody wants it to be in that situation, but that is where we are. And there's not a motion asking this court to set a bond on this matter. It's only the motion to compel based on a deadline that is not final. It is not enforceable yet. That was what these three motions are here about. So we reassert our position that the Rule 3602 language specifically requires admissions to be deemed admitted, and that is conclusively established unless by motion requested withdrawal or amendment of those admissions properly by the non-responding party. And that was not timely or properly done. That is the respondent in the state's position. That is the basis of the Rule 59 motion. That's the basis of the Rule 9 motion for interlocutory appeal on that order. Now, Ms. Emick has hinted of trying to prevent any undue injustice to her clients, the petitioners, the Elliots. The respondent takes that same position. That's a grounds for Rule 5904, to prevent any injustice by any party, including Ms. Williams and including the estate. And there's these issues about delays. Nobody wants this case to be delayed. This court wants this estate to be properly administered. The estate has filed at least 2 motions to disperse or distribute funds. There's over $500,000 lodged with the court as of today that's accruing interest daily. Everybody can all agree, I think it's the only thing we can agree on, that everybody wants this estate administered and resolved. But The respondent and the estate jointly agree with this court that we do not see mediation as fruitful despite these circumstances, but we request that this court reconsider and alter or amend its judgment based on the lack of good cause of the pattern of behavior throughout the discovery process by the petitioners. I defer the rest of my time to Mr. Duvall.
Your Honor, please, for judicial economy, I will refrain from reiterating any of our positions. I apologize, Your Honor. For judicial economy, I think Mr. Triplett has adequately stated our position. Ms. Emick referenced a dozen requests. That's not true, Your Honor. My computer does not show a dozen emails from Ms. Emick in the 3 or 4 years of the pendency of this matter. She has filed matters late. She has reworked. She has continually made allegations, but they have little to no proof. They did not file a petition to remove Ms. Williams as the executrix of the decedent's husband when Ms. Williams executed a deed to $1 million piece of property that they inherited through Carney Elliott. They didn't object to that, Your Honor, but they made repeated allegations defaming this lady, and we submit.
I've not heard that before. Is that some new piece of evidence that you had yet to be?
Well, Your Honor, the court can look back at the estate of Carney Elliott, and Ms. Williams executed a deed of trust for the Elliott Family Farm Trust, valued at $2 million conservatively, and Ms. Williams executed that deed and delivered it to the Elliots in the estate of Carney Elliott, and we closed that estate. So they didn't complain of anything when they got $1 million piece of property. Respectfully, Your Honor. Thank you.
Your Honor, I'll just say that that was a will, and that Barney Elliott left.
Oh, I'm going to deal with one estate at a time.
Yes, Your Honor. I just asked that. I could go back and forth too, Your Honor. I think at the end of the day, we need to move forward. We need to finalize this. We need financial documents to show what the damages are, and we're ready to move forward with that, Your Honor. Setting a final date.
When I first considered the motion to deem the request for admissions to be admitted, and we had that hearing back in March of this year, I considered the entirety of this case, including all of the hearings that we've had before, the general attitude and what has taken place in the courtroom on many occasions, and the general anger and hostility that exists, it seems, between these parties. And I'm in my order on that, following that hearing, made several findings. One of them was that this was a case involving a contentious and acrimonious estate litigation. I went through and cited all of the background of it and the petition to remove Virginia Williams and the allegations that she had made certain changes to the, while acting as a conservator for Anne Murphy Elliott, that she had unilaterally altered the beneficiary designation of annuities held by Tennessee farmers. I mean, these are allegations that were made. They've not been proven, but they were allegations that were made. The petition that was to remove Ms. Williams also made the allegations of misconduct or mismanagement of the estate and sought to prevent the unjust closure. Those are very serious allegations. As Ms. Emmett has repeated, there is alleged to be some $600,000 missing from the estate. As a result of that, I tried to move it forward by putting forth a scheduling order. And as Mr. DeVault says, they did comply with that order by tendering certain information and requests for admission, including as well as as well as discovery requests, interrogatories, and so forth. The problem that I had with it then, and I still have it is that, as was shown to me at the hearing, the respondents in this case are seeking the strict enforcement of the Rule 36 by saying that because they were late in answering the request for admissions, that it should be mandatory that the request be deemed to be admitted. And they've made that argument today again. I have looked at the law in that particular situation. I did considerable research on it. And, you know, the evidence at that hearing was that the petitioners have requested additional 10 days to provide the answers to the discovery. It's also important to keep in mind that I think this ran during the holidays, and that I made a finding that it was understandable that the petitioner's counsel would probably have difficulty in getting the answers, and requesting an additional 10 days was reasonable under those circumstances. I found that there was a basis for an enlargement of the time, and that the granting of the request to deem the request for admission to be admitted was extremely punitive and was not warranted under the circumstances. I went on to cite the rules as well as the Court of Appeals decisions. For example, in the Tennessee Court of Appeals decision of Meyer Laminates Incorporated versus Primavera Distributing Incorporated, I quoted the language from the Court of Appeals that said, "We are of the opinion that the clear language of Tennessee Rule Civil Procedure Rule 36 provides that the trial court discretion to allow withdrawal or amendment of matters deemed admitted because of the party's failure to timely provide answers to a request for admission, including when no response has been provided by a party who has received a request for admission." You know, this case raises allegations that haven't been proven involving potential violation of a fiduciary duty of a conservatorship and an estate. And while this, you know, the respondent is adamant that those are false, it does seem to me that it is the type of situation that this court wants to have the hearing on the merits rather than on a technicality of failure to comply with a 30-day window for request for admission. And as the Meyer Court went on to say, the discretion afforded the trial court under Rule 36.02 to permit the withdrawal or amendment of matters deemed admitted provides a modicum of flexibility to avoid any potential injustice that might occur from the strict and unyielding application of the 30 or 45-day deadline prescribed in Rule 36.01. Under those facts, it is this court's opinion that the order that I put down was appropriate. It denied the request to deem them admitted. And I think that the court, since I based it upon the language of the Tennessee Court of Appeals decisions that I think are most applicable, I don't believe that an interlocutory appeal to the Court of Appeals would result in any change in that. Therefore, I would have to make certain findings in a Rule 9 appeal, and I would have to make certain specific findings and statements that the legal criteria for making the order appealable is provided under subdivision A of this rule, which is basically the need to prevent irreparable injury, giving consideration to severity of potential injury, the probability of the occurrence, and the probability that review upon entry of final judgment will be ineffective, the need to prevent needless, expensive, and protracted litigation. I understand that the respondent's argument is that, hey, if I grant these requests for admission, then that pretty much is going to terminate this whole thing, because they're basically saying that it would render the petitioner's situation untenable. I'm of the opinion that my opinion was correct, my ruling was correct. I'm of the opinion that a Court of Appeals would affirm that, and therefore I do not find that there is a basis under Rule 9 for an appeal, an interlocutory appeal. This case has been pending for years. It needs to be resolved, and granting an interlocutory appeal would add probably another year of limbo while this case went up on appeal, and both sides were given the opportunity to present the transcript, the argument, the briefs, argument, set it for the oral argument. In 6 months to a year at least would be added to this case. So therefore, I find that the motion for an interlocutory appeal should be denied in the interest of justice. I deny the motion to alter or amend the prior order of this court. I'm going to put an order down that both sides will submit to the other within 15 days a statement of deficiency of discovery, meaning both sides will submit what articles of discovery are no longer or have not been supplied that were requested, or what the deficiencies are. And after the receipt of that, both parties will have 30 days to comply, to bring their discovery current, or file an objection to the discovery, which will have to be dealt with, obviously. In addition to that, I have reserved the question in my prior ruling about the failure to, if that either party wants to depose one of the parties, then they will have the right. That deposition will be set by agreement. It will not be noticed. And if the parties cannot agree, then you may contact this court and I will set a date and time for the deposition of the party. All other matters are pending. I fully understand that there's Rule 10 extraordinary appeal that's available to the respondent in this case, and certainly they have every right to pursue that if they choose to. But it's my opinion that a grant of an interlocutory appeal would just be more damaging to the disposition of this case than denying it. So I have done that. And as far as your motion to compel, I'm not granting any sanctions to either side about that. I'm putting this order down to try to finalize the discovery. Once you have done that, I expect it will take several days to try this case. Is that correct?
Yes, Your Honor.
Most likely, Your Honor.
Your Honor, may I ask the court, instead of saying 15 days, because the computation of time, less than 30 days can get confusing when you don't factor in weekends and everything else, can we just set a date certain so that there's no questions or loopholes for these parties to wiggle around
So
with?
what are you proposing?
15 days from today, Your Honor, would be what, 22nd of July? Is that correct? So maybe we just set
Today's
the
the
actual.
7th, 15th would be 22.
So Your Honor, maybe we just set the date instead of.
All right, all discovery, the notice of deficiency of discovery will be filed by both parties by no later than July the 31st. Thereafter, both parties will have 30 days to supplement their discovery to correct any deficiencies. Either side has the right to apply to the court for a hearing on the discovery issues, but I want this to try to be resolved. Now, once you've done that, you're looking at the 1st of September before, and I'm back here in November. You have anything? You got your calendar. How long, realistically, assuming that the Court of Appeals does not grant an interlocutory appeal under Rule 10, how long do we expect this to take to try this case?
I think 3 days, Your Honor.
How long?
3 days.
3 days.
Yes.
We could probably do it in 2, Your Honor, but just out of abundance of caution, so we're not splitting trial over months if we can help it.
And we've got more than one court with now, so even if you're not here. What about December the 28th, 29th, and 30th?
I'm available.
I mean, that's so far out. I don't have anything on my calendar, Your Honor.
Your Honor, respectfully, that's during the holidays.
Well,
My son and grandson has a habit to come up here for Christmas on the 24th, and they stay till January 1st.
where are they coming from?
Atlanta.
Well, I'm not going to
And
knock
that's
you
one
out
of
of
the 3 times that we get to see my son and grandson in the year.
and I want you to have that opportunity. So we will not set it on that night.
No objection, Your Honor.
It doesn't matter whether you objected. I'm not going to knock Mr. DeVault out of seeing his grandchildren.
Thank you, Your Honor.
Looks like it will be March 3rd, 4th, and 5th. Again, this is all based on, obviously, if they have every right to seek a Rule 10 appeal, and I understand that. But if there is no change in the status, then I'm assigning those 3 days as your trial date. Any problem with those dates?
No, Your Honor.
All right. I need an order drawn. Obviously, it needs to be drawn as quickly so that if they're going to pursue a Rule 10 appeal, they need that order in the records.
Your Honor, respectfully, who is to draw that order?
I can draft.
Ms. Emmett will allow the petitioners to draw the order.
Thank you, Your Honor.
Let's try to get it done as soon as possible.
Yes, Your Honor.
Thank you, Your Honor.
All right. Ms. Roberts, you have the last case on the docket.
Case for hearing, Your Honor.
All right. Let me go backwards then and see. We had skipped over, I think, the In re Siobhan Martin.